Good afternoon. Thanks for coming to the event today. We appreciate seeing everybody, and enjoy your lunch while we continue on. Maybe pay attention a little bit while you eat, but thanks for coming. So today we're pleased to have an event from the Mackinac Center we've entitled "Is This Working? The Effects of Occupational Licensing on the Workforce." Working a job, any job, is connected to lower poverty, better income mobility, lower crime rates, fewer children born out of wedlock, and a host of other positive results. But today, the right to earn a living is becoming increasingly difficult, particularly in the area of licensing. In 1950, only about 5% of workers needed an occupational license to work. Today, more than 1 out of every 5 workers in Michigan needs one. This type of special government permission to work. This typically includes mandated educational degrees, hours of training, upfront fees, testing, continuing education, and limits on people with criminal backgrounds. But there might be some hope. The Obama and Trump administrations have both focused on licensing rules, working to encourage states to lessen the burden. And research from scholars across the political spectrum are in agreement that these regulations tend to stifle innovation, raise prices, reduce the number of jobs, encourage income inequality, and even raise prison rates. Today's event will talk from 3 scholars who will talk about their research on occupational licensing, kind of in 3 different areas. So each of our scholars kind of covers a few different things. First up, we're going to have Ed Timmons. Dr. Ed Timmons is a professor of economics and the director of the Knee Center for the Study of Occupational Regulation at St. Francis University in Pennsylvania. His research on the effects of occupational licensing has been published in the Journal of Law and Economics, the Journal of Labor Research, the British Journal of Industrial Relations, Health Policy Monthly Review, and the Eastern Economic Journal. Ed's going to focus on the economic effects of licensing rules. Dr. Steve Slavinsky is a senior research fellow at the Center for the Study of Economic Liberty at Arizona State University. His work focuses on the effects of occupational licensing on criminal recidivism rates. And Rebecca Allensworth is a professor of law at Vanderbilt. She studies the antitrust implications of occupational licensing and explores the theoretical basis of the rule of reason and its application to self-regulation. So we'll let our panel take it away. We'll let them each talk for a little bit, and then I'll moderate some questions. If you have questions, we have comment cards out on your table, so please fill those out as you think of them. And then we'll hand them in and take care of that at the end. So go ahead, Dr. Timmons.
Well, Jared, thank you so much for inviting me to this event. It's wonderful to be here in Michigan. And I'm not a Penn State fan, so don't hold my geography against me as I'm speaking here. So what I'm going to talk about is I'm going to talk about the various areas that we're working at the Knee Center. I'm going to touch upon our website and one of our primary objectives at the Knee Center. I'm also going to spend some time talking a little bit about some of the research I've done on the removal of these laws. Jared did a nice job of summarizing what we understand and what there's bipartisan consensus of what the effects of licensing laws in fact are. I'm also going to touch upon non-physician scope of practice, and then finally talk about some research I've done on tying together licensing and economic mobility. So this here is a screen capture. I'm pretty proud of myself for pulling this off. I'm not the most technologically adept person. But here's a screen capture of our website, csorsfu.com. And what you can find here on this website is a catalog or directory, if you will, of what licensing statutes look like on a state-by-state basis. We're focused right now on healthcare professions. We do intend to have this be all-encompassing to include all occupations. What I've pulled up here are the licensing requirements for perfusionists in Pennsylvania. Michigan does not license perfusionists, but what perfusionists do, these are the folks in the healthcare area that operate heart and lung machines. So we're working on documenting what these requirements look like And we're right now doing a review for Pennsylvania, cataloging what licensing requirements look like for the state. With respect to the removal of licensing laws, this is a very rare occurrence. Michigan has been a bit of a leader with respect to the changes that they've made, delicensing a handful of occupations. But I take a look at a couple of specific cases. Number one, Alabama, for the period of 1983 to 2013, did not license barbers. So what I do is I try and understand, number one, what was the effect of removing this licensing law. And what I find is very much consistent with what we might expect. Once licensing was removed, barber wages do in fact fall. And I have a new paper that will be coming out from the Mackinac Center very soon, taking a look at the effects of reintroducing barber licensing in the state of Alabama. And what I find there is that the receipts of shops do in fact increase once licensing is reintroduced. And secondly, the growth in the shops. There's fewer shops once it becomes harder, once it goes from there being no requirement to be a barber in the state of Alabama to requiring 1,000 hours of education. I also did a paper for the Mercatus Center looking at the effects of removing hair braiding licensing. This is an issue that received considerable press. And using Virginia in this case as a case study since they removed hair braiding regulation in 2012. And what I find is that there's an increase in the number of smaller shops. I find a very similar percentage, 7 to 8%, pending if I'm comparing bordering states or focusing on the bordering counties. So either one of those yields results that are very much in line with what we would expect, namely that requiring hair braiders to get a license is preventing individuals from entering that field. I'm also very interested in just tracking delicensing efforts, going back to a paper that I did for the Bureau of Labor Statistics. Michigan, as I said, is very much at the forefront of removing licensing legislation. Prior to Michigan, going back 30 years, I was only able to find 8 cases of licensing legislation being removed. So it's not a very common occurrence. It's much more common for new occupations to be licensed. And we might expect this given we've gone from 5% of the workforce being directly affected by these laws in the 1950s to anywhere from 22 to 29%, depending upon the report that you're looking at. This here is a map of what the practice environment looks like for nurse practitioners. I am very interested in understanding what scope of practice looks like for non-physicians. I think it has important ramifications for the health care that gets delivered to individuals. Yes, it is important to understand hair braider licensing and barber licensing, but with such a high percentage of workers directly affected by these laws, I think it's also important to look at the healthcare sector as well. For instance, you can see Michigan there is red in a sea of yellow there. Michigan does have one of the more restrictive scope of practice laws with respect to nurse practitioners. Nurse practitioners must, in order to prescribe controlled substances, they must be supervised or have some form of delegation with physicians. Those states in yellow, so for instance Pennsylvania, physicians and nurse practitioners can enter into a collaborative practice agreement, and this allows nurse practitioners to operate a little bit more autonomously. All those states that are green, Iowa, Maryland, in those states nurse practitioners are free to practice without any oversight by physicians. So they're free to practice to the full extent of their training, they're not doing surgery, but they're able to do more traditional primary care types of roles with patients without physician oversight. Another non-physician provider I've done some research on is physical therapists. In Michigan, physical therapists are only permitted to see a patient without a physician referral for 21 days or 10 visits, whichever comes first. So, if I'm a patient, why go see a physical therapist if I know in 3 weeks I'm going to have to go see a physician anyway? In a variety of other states, Maryland, Iowa, there's no such restriction. I can see a physical therapist for as long as it takes for me to get treated. So this is another area of interest to me, and there's important differences across states, particularly for Michigan. Then lastly, I'm doing some research right now trying to look at the relationship between licensing and economic mobility. Does licensing prevent individuals from achieving the American dream? Does licensing prevent individuals from climbing the economic ladder? And what we do seem to be finding, this is a paper that will be coming out from the Archbridge Institute within the next couple of months, is that licensing growth, more specifically growth in the number of licensed occupations, we created a new data set looking at the snapshot of what licensing looked like in 1993, matching that to the pioneering, wonderful work of the Institute for Justice with the snapshot in 2012. And we find that those states that have had more occupations licensed over that period, there does appear to be less opportunity for economic mobility. So I'm going to turn things over to Rebecca.
Actually, I think I'm going second.
Oh, I'm sorry. That's
all right. That's okay. Go ahead and stand up here if that's all right. Thanks all for coming. My name is Steve Slavinsky at the Center for the Study of Economic Liberty at Arizona State University, and we'll have some slides up in a minute. But what I'm going to talk about today is about the actual impacts, the employment impacts on people that are resulting from these occupational licensing laws. If you need a permission slip to work by the government, you can see how this could be a big problem if you're a certain kind of person who may not be eligible for those types of permission slips, if you will. And that's going to have a very real impact on your ability to move up the income ladder. As Ed just talked about, income mobility and opportunity are hindered by burdensome licensing restrictions. And so I'm going to talk a little bit about two specific areas in which you see this most dramatically. And Ed did talk a little bit about scope of practice, nurses, things of this sort. Those might be considered high-end professions, right? Doctors seem to make a little more money than most other people. I like to look at the low-income professions, mainly because there's a lot of good data that are coming out now about this specific group of people, but also because this is where you hear a lot of the press stories about occupational licensing, the barbers, the landscape workers, the child care workers. These are folks who are being burdened in differential ways across different states. Depending upon what state you live in, it might be harder to get a barber's license than in another state. And that's going to have a very real impact on your employment prospects and your ability to move up the income ladder. I'll just do a little briefly, and the slides aren't really going to be necessary until probably the very end. Let me just give you some broader ideas of what I'm talking about here. If you think about low-income entrepreneurs, we think about folks who are basically in the bottom 2 quintiles of income in any specific state. And you can look at what they look like. For the most part, they tend to be predominantly male. They also tend to be predominantly Hispanic and Latino and immigrant, but they also have lower levels of education. Well, what I mean by that is over half of them, roughly, tend to be only achieving a high school diploma and then nothing else beyond that, maybe even maybe even just high school classes, not an actual even a diploma in those cases. And this is a problem in some states because there are some occupations in some states that require you have a high school degree to even carry the license. In fact, you might have heard a story recently in the state of Tennessee. There's a gentleman who was actually arrested or at least shaken down by the licensing board in Tennessee for being a barber because he did actually not have a high school diploma, which is patently ridiculous, but these are the kinds of restrictions that government is kind of perpetrating on the marketplace. And of course, it's having all of these downstream effects, and not just ruining the lives of people who might want to practice in this field, but also their customers. Prices are going to be higher if you restrict the number of people that can get into the occupation or the industry, and that's roughly what you see when it comes to occupational licensing. Let me kind of skip forward here to this is just an indication that low-income entrepreneurship is important and a really good way of kind of creating income mobility, as Ed had already discussed, and I'm happy to give you those citations later. Here's that demographic profile I talked about. As you can see, if you look on the right, low-income entrepreneurs, 67% male, much higher than their normal representation in the general population, predominantly Hispanic and Latino, 9% general population, 24% among low-income entrepreneurs, and then largely immigrants. So again, if we're interested in thinking about how do you reintegrate or integrate immigrants into the economy, how do we get people mobilized and moving up the income spectrum, putting barriers in their path to prosperity are going to have a real impact. And, well, here's what happens with the data. This is what they call a scatter plot. I promise this won't hurt. Basically, what you do is you can look at the relationship between, in this case, the percentage of the low-income occupations that are licensed. That means that's a 0 or a 1. That's like, do you license it or do you not license it? Look at that across all 50 states in the Institute for Justice data. Then you look at the vertical axis. That's the entrepreneurship rate. That's the number of people, basically, as a percentage of the whole, who are self-employed entrepreneurs in all of the industries that are being licensed. And you see this downward trend. In this chart, you want to be on the top left. You want to have the lowest percentage of occupations licensed and the highest rate. And so as you see, the further down you go, the more stringent you get, the more burdensome you get the less entrepreneurship. So, and that's true even after you adjust for factors that might explain that difference. Demographic factors, economic conditions, like the overall health of the economy, and yet you still see the significant negative impact on low-income entrepreneurs. Now, there's also a criminal justice component here. That's what we call the collateral consequences of occupational licensing. If you're thinking about a group of people who have similar demographic attributes, they might generally tend to be lower levels of schooling, lower levels of educational attainment. Those are folks coming out of prison. This is a real problem for reentry into the workforce, is that a lot of these folks don't have sometimes the requisite job skills and certainly not the degrees to hold licenses in a lot of these occupations. And yet we see time and time again for decades worth of studies that gainful employment is a vitally important means to keep ex-prisoners out of prison. In economics, we have something called opportunity cost. It basically means what's your best other option when you're compared with a choice. If you're being locked out of the workforce because the government has licensing restrictions that keep you out of the workforce, you might turn back to crime. You might be more likely to recidivate, as they say. And education programs in prison and continuing education out of prison, they can increase the probability of employment once you get out of jail. But here's the real big problem. In many states, these occupational licensing barriers are harder to overcome. Even if you had the skill level you would need to get a licensing degree, many states have what they call good character provisions. That basically means that we don't really care how skilled you are or how much knowledge you have of this field. If you have a criminal record, you can't even apply for a license, or if you do, you're going to be rejected automatically. Some states have blanket bans on people with records applying. Other states are a little more esoteric, but for the most part, what you see is, and the American Bar Association has gone through over 11,000 state statutes in all 50 states and gauged and measured the severity of those good character provisions. Some states will even say, regardless of what your regardless of your criminal status, meaning whether you're in prison or not, sometimes a misdemeanor arrest can trigger a red flag in an application for an occupational license. Sometimes a nonviolent misdemeanor can invalidate your ability to get a license. And of course, this again is going to lock these folks out of the workforce. And so this is a real big problem. And so there is an obvious nexus point here with criminal justice reform. You do the similar type of analysis here that I did. Oh, here we go. Actually, there we go. So if you look at the states that have the heaviest burdens, and by that I mean not just the heaviest licensing burdens, meaning it takes the longest to get the license, it's the highest fees. It's also the states that have the most stringent good character provisions, blanket bans, for instance, on folks with a criminal record being able to apply for a license. And you look at what their recidivism rate looks like. In this case, we looked at between 1997 and 2007. And those high burden states actually had an increase of over 9% in the reoffense, or as they say, the recidivism. And this is actually what they call the 3-year recidivism rate. And this isn't even just technical violations like failure to pass a drug test or you miss a meeting with your probation officer. This is basically brand new crimes that are being committed as a result of being locked out of the workforce. And you see a 9% increase in those high burden states. The national average, you still saw an increase, 2.5%, not huge, but that's over a 10-year period, not too bad. It seemed to be under control. But yet the low burden states, the states that did not have these good character provisions or very, very minor, weak versions of them, and they also had the lowest barriers to entry for people even without a criminal record, they actually saw a recidivism rate drop in that 10-year period, which is pretty remarkable considering the nation as a whole tended to see increases during that period. Here's again, this is that scatter plot I talked about, same thing. In this case, you don't want to be in the top left, right? In that case, that's where you have the highest growth in the recidivism and the worst occupational licensing score. In this case, you want a high score at the bottom. The lightest burden is the closer to 1, and the reductions in the recidivism rate are below that middle line there. And again, you see a downward trend here. So what does this all mean? Well, again, if you do the analysis in the same way, you adjust for the factors that might explain this difference, you discover that there's still a significant effect on the state's ability to decrease their recidivism rate. Now, in terms of trying to employ, and this will be the last slide, and we'll let Rebecca talk about the broader legal issues here. But for the most part, if you're thinking about ways of reintegrating folks into the folks coming out of prison into the employment market, into the labor market, and giving them a new chance on life. Other opportunities or other policy ideas that people have put forward is something called ban the box, which you might have seen. Basically, it means if you're applying for a job and you have a criminal record, in some states or cities, it is illegal to actually ask people about their criminal status. The only problem there is that if an employer is not sure about an applicant and they can't screen for criminal record, they might actually just not call that person back. And some of the more recent studies on this have indicated that, because these bans are relatively new, that has actually sort of increased the rate of discrimination in the job market. So part of that reason is because they just can't screen for it and they don't quite know what to expect. But the worst, and this is made even worse by the fact that in most places you can't even apply for a job unless you have a license. And if you can't get a license because you have a criminal record, you don't even get to the ban the box stage. And so I would argue that the occupational licensing burdens that we're imposing on people coming out of prison, hindering their reentry into society, this is, I think, going to have the bigger impact on their livelihood and their ability to pick themselves up by their bootstraps. And so I would argue that criminal justice reform and occupational licensing reform are jointly concerned. They should be thought about in the aggregate as a whole. And I think it would help not just the individuals themselves, but I think society as a whole generally, with lower crime rates, greater opportunity, and more prosperity for the state as a whole. So thanks very much, and I'll turn it over to Rebecca.
Hi, I just wanted to also thank you for being here. Thanks for inviting me to speak about my research. My co-panelists, I'm Rebecca Allensworth from Vanderbilt Law School. I guess I've got a little sign here, but. So my colleagues have done a great job of kind of summing up the substance of this regulation and how it can have some pretty negative effects both on the market for the services and also on the people who would be wanting to provide the services. I tried to study how this regulation gets made, so in some ways how the sausage is made. I studied the legal and regulatory infrastructure that is behind some of this regulation that ends up having a bad effect on folks. So who is responsible for excessive occupational licensing? The blame is shared between state legislatures and the boards to which they delegate the regulation. So let me talk about boards first. I studied all the boards. I found all the boards in the U.S. There's about 1,800 of them. Each state has an average of about 35. Some have fewer, some have more. And I found that about 85% of them were required by statute to be dominated by currently licensed working professionals in the profession that the board regulates. That means that this is almost an entirely self-regulatory system to the extent that the boards are making the regulations and enforcing them. And that, I think, is a big part of how we get to this set of rules that end up costing consumers, costing workers, at the expense of the incumbent professionals. State legislatures are also to blame. So first of all, states sometimes license occupations that shouldn't be licensed at all. I know Michigan has done some good work rolling back a few of these. There's also a lot of actual entry and practice rules that are created by statute. So in Michigan, for example, the number of hours that a barber must go to school before becoming a barber is set by statute. So sometimes the rules are set by legislatures, but sometimes they are set by boards. Another thing that legislatures do that I think is really important is that they hand over the reins of competition to these boards, which are basically almost industry groups. In Michigan, the state constitution requires that these boards be 2/3 practitioners, and that's consistent with the rest of my research showing that most boards in the U.S. are that way as well. Okay, so given that there's this shared blame and this shared responsibility for regulation, what can be done? I think state governments need to take more responsibility for their occupational regulation. It should be like the rest of regulation. It should be done by at least nominally disinterested people. It should be exposed to political pressures. You know, occupational licensing is becoming less and less popular. If you look in Vox and Slate and New York Times, Wall Street Journal, it seems like every week there's a new piece about how this has gone too far. Let's expose occupational regulation to that kind of changing opinion. Right now, when it's done by the boards, it's rather insulated from that. And it should also be done with the things that only government has, which is expertise and resources to gather the kind of data that my colleagues have put a lot of effort into creating in order to decide whether or not, in order to trade off these potentially health and safety benefits to the cost to the consumer and to the worker. And as it is right now, a lot of occupational licensing is not done by something that I recognize as government. It's done by these boards. So why should states do this? Well, it's the right thing to do. But there's another reason now why states should do this and take more responsibility for their regulation rather than handing it over to a dominated board. And that's a little thing called antitrust law, and that's how I got into this. I'm an antitrust law professor. And in 2015, the U.S. Supreme Court decided that a state licensing board made up of mostly practitioners could be liable under antitrust laws. So in other words, you could sue in federal court under the Sherman Act a board for creating an anti-competitive regulation. Anti-competitive is the word that antitrust people use for unfair, inefficient, onerous. And the board members would be personally, trebly, which is another fancy word for triple, liable for the damages. So in antitrust lawsuits, you get 3 times your actual damages. Well, this was not something that boards wanted. And what the court held was that those lawsuits could go forward if the state did not actively supervise those boards. So the real question that all the states had after this case, and that was really the focus, was what does this mean, active supervision? And everyone was trying to actively supervise their boards so that they would get that immunity from the antitrust laws again. So here's the question: what constitutes active supervision? To me, this question is actually 2 questions. First, there's the question of what the Supreme Court thinks is active supervision. And unfortunately, we really don't know what that is. The court has decided a few cases about it. It's never been very clear. The more interesting and I think important question is, what should the state do to really rein in these licensing boards? What is required? And I think that actually answers the first question too. Because what states need to do is they need to hold themselves accountable. They need to involve disinterested decision makers. They need to harness the expertise and resources, all the things that I just said. And we know that the Supreme Court really cares about the same stuff that I'm talking about. The Supreme Court really cares that this is self-regulation and that it seems to have gone too far. So in my opinion, if the states do the right thing, if the states take more transparent responsibility for their regulation, they will kill 2 birds with 1 stone. First, they will get some of their licensing problems under control, and second, they'll get the federal antitrust laws off their back. I think there's an organization in Michigan, LARA, and a lot of the occupational regulation rules go through them. I think that's a natural supervisor. I think that's a real potential to create the kind of active supervision that the court requires and that, in my opinion, the substance requires. I'm not sure LARA is there yet, but I think that there's ways in which it could be endowed with stronger supervisory powers over these dominated boards. So just a little background on what other states have done. So 8 states have created statutes purporting to create active supervision. About 8 states have introduced them and failed. And there's about 3 states that have pending legislation creating active supervision. Michigan's not one of these, I think actually because maybe there's a belief that LARA is doing the supervising. I like some of these models better than others. I'm happy to go into this in the Q&A. It's a little bit like in the weeds. But I think that, long story short, you need to have an executive agency with the kind of staff and resources to really look at this rules and regulation and say, this is something that's good for the state of Michigan. It can't just be a rubber stamp. There's also a little bit of federal involvement here, which is interesting. There is a bill pending in the House of Representatives, introduced by Darrell Issa, that would give states a new route to immunity, so this thing they're all afraid of, these antitrust lawsuits. The feds are saying, look, you'll be immune if you do this other set of things. And that other set of things is basically creating a policy of only using licensing when it's efficient, and then either supervising those boards to ensure compliance with that policy, or creating a private right of action that workers can use to sue over those potentially inefficient and unfair licensing laws. So in closing, that's another thing that I would be happy to talk about more in the questions. That federal bill I think is really interesting. I think it has a lot of promise. It's in early stages, and in my opinion, it's not quite there yet, but I do think it's something that should, in revised form, be passed. So I have two thoughts in closing. First, I'd like to say that state legislatures sharing the blame is bad news on the one hand, but it's also good news because it means that the state legislature can do something about it. And the last thought I want to offer is, it's not enough to deregulate. It's easy to focus on the hair braiders and the florists, but there are occupations that are best regulated through entry restrictions, educational requirements, and professional discipline. In other words, there are a lot of professions and a lot of a percentage of the workforce, such as in healthcare, that should be regulated through licensing. So what are we going to do about the nurses and doctors? They are subject to all the same pathologies of self-regulation, and so it's important for states to rein in those boards too.
All right, please thank our panel. If you have a question, please write it down on a comment card, and then we'll have one of my colleagues will go pick them up. But I have a couple to get us started here. So I'll do one for each of you. So I usually say for Q&A, nobody ever left a Q&A saying, man, I wish that guy had answered that question a lot longer. So as brief as you can while getting the information out there. So Dr. Timmons, you mentioned that one of the effects on once an industry gets licensed is you see higher wages for the people in that industry, which that sounds pretty good to me. If those people are getting higher wages, why is that not something we would want?
So if barbers are in fact receiving higher wages, what that means is that all of us are paying more for haircuts. So from those that aren't in the industry, what licensing translates into, its basic supply and demand. We might all have maybe not so good recollections of our economics classes, but if supply goes down, and that's what licensing does, it makes it harder to enter a profession. What we expect to see happen is that we do expect to see prices rise. Also, those that aren't necessarily able to meet the requirements for entry, they might find themselves facing a situation where they get blocked out of the labor market, and it affects disadvantaged groups, for instance, those with criminal backgrounds, as Steve talked about. They might not necessarily have a pathway to re-enter the workforce.
So in a sense, you're redistributing income from consumers or from other people potentially in the occupation to a group that's able to go through and get the license.
That's right.
Steve, why do we want criminals working in our homes in these occupations?
Well, they don't have to be working in homes. I mean, but having a job is an important aspect of this. And part of the reason I think there's such a problem with how the occupational licensing works in practice is a lot of these statutes are really arbitrary. No one's talking about giving Bernie Madoff a financial advisor's license, right? If he wants to do that, no state will give him that license. However, if he wants to build houses, not so sure the state has a compelling interest to be able to keep him out of doing that if he wants to do that. And so a lot of this comes down to just a very overbroad application of criminal statutes, an overbroad application of this category of good moral character or are some kind of offense. Nonviolent drug offenders might have done something stupid in their youth, but it shouldn't be marking them for their entire adult lives while they're in the labor market. And that's really what these laws do, is they try to impact the person's future based on something they've done in the past, and that might be completely unrelated to the job and license they're applying for. So I think having more kind of surgical impacts or surgical approaches to how these things are defined in state law is going to be important, because any amount of criminal justice reform you do at the state level about keeping people out of prison, rehabilitation programs and all that sort of thing, that will fall apart if you're not able to give them an opportunity once they're out of those types of programs. And doing that by allowing you to get these licensing provisions scaled back for those sensitive populations, I think is an important part in all of that.
Rebecca, you talk a little bit about the legal end and the high end at the constitutional level. Can you talk a little bit more about, it seems like we're seeing more cases more along the lines of, and a lot of them haven't gone very far, but along the lines of, I suppose in layman's term as a non-attorney, that people saying, I have a right to earn a living and the government should not restrict it unless they have a really good reason. In legal terms, can you explain, are there cases about that? Can you talk about those at all?
Absolutely. So this is really interesting. Institute for Justice would be one of the main organizations that brings these lawsuits. These are constitutional, typically federal constitutional challenges against the licensing, saying that they burden the right to earn a living. Now, right to earn a living you may not think of as existing on the same footing as free speech, and you would be right. So even though there is a bit of a movement afoot, it is still mostly true that when a court evaluates whether or not somebody has a right to not be restricted in this way, they do it with something called the rational basis test. Let me tell you the things that have passed the rational basis test. We need to license florists because an unlicensed florist may place a wire incorrectly in the flower arrangement that when you go to grab it, you could prick yourself. And so we need to outlaw the unlicensed practice of floral arranging. That passed the rational basis test. That's a pretty extreme example, but really you don't have to make much of an argument. So what I would say is some of these lawsuits have actually had some success. I think there's been some success in terms of shampooing. I know they're going to challenge that high school diploma for barbers under the same terms. But it's really at the margins. It's really at the outsides, and unfortunately the constitutional tool is rather weak.
So we had a couple of questions here. I'll try to combine them best I can. Kind of on the health and safety side. That's the key argument, and this is for any of you or all of you. So isn't licensing set up to protect the health and safety of the public? Does it do a good job of that? And if we're going to get rid of licensing, how do we do so while ensuring that we're protecting health and safety?
I'll take that. The Obama White House in the summer of 2015, they did a summary of studies that have tried to estimate the effect of licensing on the quality of services delivered to consumers. And what they found is that just 2 of the 12 studies found any evidence, and it was not very strong evidence, that licensing does in fact enhance quality. I think it's important to note that when we talk about the possibility of removing licensing, we're not necessarily saying there's not going to be any regulation at place. It's not a binary choice between no regulation whatsoever and the very onerous regulation of licensing. There are a number of other regulations, and the Institute for Justice has an inverted pyramid that shows the other avenues for regulating. For instance, certification. You can require individuals, if they're going to use a specific title, that they meet bare minimum requirement. And you don't impose the same barriers to entry as you do with licensing. There's bonding, there's all sorts of there's inspections, there's all sorts of other regulations that can be used, and it's important to consider which one of those is going to do the least harm and still achieve the objective of making sure that individuals do in fact receive the best quality of service and that the public health is not being jeopardized.
And I also want to add on to the health and safety aspects of it, because Jared, you mentioned these laws were designed, or at least I should say passed, with the impetus and the intent of protecting the health and safety, but these were passed decades ago. Technologically, we've advanced so far. In fact, in terms of health and safety, especially in terms of reputation, bad haircuts and things of this sort that don't really have a compelling health and safety component to them, we can figure it out pretty quickly because we have these wonderful devices in our pockets, these pocket computers that basically have power that are in excess of what the space program had in the 1960s. So we have ways of finding out these things. And so licensing laws are a very kludgy, overbroad way of trying to protect the public in ways that was only, meaning I should say the law was the only way to do that at some point in the past, but I think that's no longer true. And so revisiting these laws, even just in the context of the world in which we live, is going to automatically, by definition, I think, make it more likely that these types of things will get scaled back.
And just to put my perspective on this too, it's really about, to me, it's about the who, not necessarily the what. So when you ask a florist, is there a public and health and safety, aspect to what you do? Guess what the answer is? Yes.
Right.
Yeah, the Michigan legislators 4 years ago tried to tack back the mandated hours for barbers in the state of Michigan from 2,000 back to 1,800. They initially were talking about going further than that, and I recall one of the barber school, the guy that ran the barber school, saying that barbers weren't quite doctors, but they were as close as you could get in the state of Michigan. It was very hazardous. Not a barbershop I'd been in, I guess. But so if the state delicenses or drops these good character clauses, how is the state going to screen out people who do pose a danger of or a threat to public health and safety?
Sure. So one way of doing this is to basically take a look at the offense for which they have a record, and if it's related to the specific. So I mean, drunk drivers getting a taxi cab driver's license. I can see how you'd want to try to keep those folks. That sort of thing the recurrence of that sort of thing is more common than other types of offenses. But I also do think that a lot of it comes down to what the comfort level of the employer is, right? It's not the state's job to say you should or should not be able to apply for a job in this field. It should say, okay, if you meet these requirements that we've set, we will give you this license, and then it's up to the employer to decide if you are a risk or an insurance threat, and whether they will hire you. And employers have their own screening processes. In fact, one of the scholars we work with, Dr. Morris Kleiner from University of Minnesota, right? And he's actually done some work with Uber. And what they've done, which is fascinating, is they've got 50 states worth of data and lots of data points. They actually did what they call a blind test. Basically, they had, and Uber has been very diligent about hiring folks with criminal records coming out of prison, getting reintegrated into the workforce to let them drive Uber cars. The thing is, though, when you get into an Uber car, you don't know if your driver is an ex-con or not. For most passengers, it doesn't matter as long as they weren't in jail for drunk driving or something. If it was a nonviolent drug offense or something, and maybe there's no reason to wonder why their driving ability would be less than others. And so you look at the quality ratings, right? Because whenever you get out of a Uber and your phone dings and you can rate the driver. Of course, they rate you too, but you can rate the driver. And you look at that data and you discover that the satisfaction rankings for people who had criminal records versus those that didn't were not at all different. There was no statistically significant difference between the two. So from an employer's perspective, there may not be any real reason to keep people with criminal records who have served their time and are rehabilitated from working for their company. So you have to leave that up to the employer. And right now, the licensing boards, by definition, effectively sort of substitute the employer's judgment for the government's judgment about whether someone should be able to work or not. And that really should be left up to the market, or the private sector, really, and the employers, and not so much the licensing boards.
Yeah, and I mean, I'd add to what Ed mentioned during his, and when you're talking about, think of people, if you're growing up in the 1960s or 1970s, you had very few occupations licensed, 5% or so. So if you didn't feel more in danger then than now, then it's probably not as much of an issue. So looking a little bit at the issue of how the practical reality of how this is regulated, for whoever wants to speak on it, are agencies taking power to do these regulations? How does a regulation work in practice? So in terms of, well, we have these people out there running around. Do we want them doing a good or bad job? is the state very overbearing on regulating those people, or are they doing barely anything at all, or whoever wants to talk about the practical side?
I think I can take that one. So I think that by and large, states don't take enough of a role. It's very passive. So a state will pass a statute saying there shall be a board of auctioneers. It shall be 7 auctioneers, 2 elderly members, and 1 member of the public. They shall hold meetings quarterly, and they shall regulate the entry and practice of auctioneering. Sometimes it's a little bit more specific than that. Sometimes, as I said, number of hours of education will end up in the statute, but it can be extremely vague. At that point, the board is then authorized to make rules, to write the exams, often to grade the exams, decide how many people pass, and then has carte blanche, essentially, in discipline. Sometimes there's some requirements that what the board does goes with the state's Administrative Procedure Act, but those procedures are kind of more about taking minutes and having a quorum and things like that. It's not very much substance. So there's not a lot of state involvement. Some states are different, and I think Michigan may be more involved than others. Colorado is another one where there is an agency sitting above the boards that takes a bit of a look, and the question is how much, at what the boards are doing. The case that I like to think about is the dental case that ended up in front of the Supreme Court. In that case, the Board of Dental Examiners decided that teeth whiteners that were not dentists were competing with them, and they sent out cease and desist letters to all the teeth whiteners saying, you are practicing dentistry and you're in violation of North Carolina law. What I ask myself in anything is your regulatory scheme set up so that a board couldn't do that without passing it by somebody who's not in the cartel? That's the question I always want to ask, and I'm not sure that that's true in very many instances.
Yeah, I know a similar example in the state of Michigan. The cosmetology board considers not hair braiding, but hair washing to fall under cosmetology, which is 1,500 hours, or in other words,
More than law school.
which is more than to be an attorney. So. So Rebecca, you are not qualified to wash hair.
Except I do it every day.
Yes, it's amazing. All right, so kind of on so what should we do? What should the state do? I mean, should legislators look at these one at a time? How do we get at what you're talking about? You can take that from each of your areas. What should, if it's a room full of legislators, we have a couple here, what should they do on this issue?
I like the sunset and sunrise things where every year there's a commission of, independent commission that's not the board, looks at 20% of the professions, 20% of the regulation, makes some recommendations, and then that goes up in front of. So I like the sunset, and that's called the sunset review because it's sort of like, well, we're going to take a look at what's on the books because there's this stickiness to everything. Things get passed and then they stick. So I like that, and I just also like the idea of resisting when the profession comes to you, the interior designers want to be licensed in the state of Tennessee, the answer is no. So it's both about rolling back what we have and also about slowing the growth. And about all the supervision stuff that I talked about.
Something else that occurs to me too, I agree with Rebecca. I think the sunset process is extremely important because it does put the default assumption and the burden of proof, frankly, on people who want to keep the current laws, right? Right now, if you don't have a sunset process, the burden of proof is on people who want to change the laws. And so flipping that burden of proof is going to be essential to reforming these things. And I think included in any sunset process has to be a discussion about the alternatives and what the real point of the law is in the first place. So the alternatives, we've talked a little bit about certification. The thing about certification that I like is it's not a government-centered thing. It doesn't give incumbent business owners a veto power over their competition. It can't say we want to keep these people out. It just says, hey, you've certified, you've shown that you can pass this test or whatever metric you want to use, and then you're allowed to practice in this field, and the government, or more specifically incumbent business owners, can't keep you out. But having that alternatives discussion needs to be part of the sunset process. And then the other part of the process needs to be discussing whether licensing, and Ed mentioned this a little bit, whether licensing laws are actually the best way to get at health and safety outcomes. In fact, one of the things Jared reminded me of, and I forgot about this, we certainly don't license cooks and bus staff at or waiters and waitresses at restaurants, and yet cooks especially, I mean, there is a definite health and safety issue here, right? I mean, you've got health concerns all over the place, and yet we don't license cooks. It doesn't mean we should license them, but it just shows you that we've handled the health and safety concerns about restaurants in a different way. We've gone through the health department. We've gone through, random checks of cleanliness and such. That's the way to deal with the health and safety issues for a lot of these professions, not keeping out competition. So that sunset process should also be required to discuss those kinds of alternatives as well.
Yeah, I mean, I would just say that there is a near bipartisan consensus that licensing is in need of reform. We know what the costs associated with licensing are. We don't have a lot of evidence that there are, in fact, benefits. When you're reading statements from the Obama White House report and comparing them from statements from individuals like Labor Secretary Acosta from the Trump administration, it's hard to distinguish who's speaking. So this should not be an issue that is a partisan one. This is an issue that potentially negatively impacts those that are at the bottom of the income distribution. This is an issue that is very, very much in need of reform.
All right. So I know our panel will have some time to stay afterwards if you have other individual questions. But for now, please thank our participants. So that concludes the panel today, but don't get too upset about it. We'll be back here next Thursday with another event, next Thursday, February 1st, on do Michigan charter schools get more bang for the buck? So if you are in town, please come join us then for another lunch and good conversation. But we appreciate you being here, and thank you for our panelists with all the information and the research as we work on these important policy issues.